going on, guys? This is Dave down in Houston. Thanks for watching. So by now just about everybody's seen that video of our guy down here in Houston getting illegally detained by the Houston police officer. And there's been a lot of discussion, in fact it's still going on Facebook about this whole situation. So I thought I'd put together a little video and give you just a common sense, real world explanation of how all this stuff works. And it really all comes down to one simple legal thing. It's called reasonable suspicion. Reasonable suspicion. Now I'm going to read you something here from a Supreme Court decision in 1968, Terry versus Ohio. And it says very plainly, in justifying the particular intrusion, the police officer must be able to point to specific and articulable facts which, taken together with rational inferences from those facts, reasonably warrants the intrusion. And also down here at the bottom of this thing, in a separate paragraph, it says that reasonable suspicion cannot be based on an inchoate and unparticularized suspicion or hunch. That word inchoate basically means incomplete, for lack of a better way to put it. But in any case, so that's what it comes down to. To have reasonable suspicion, the officer has to have specific and articulable facts that make it more likely than not that you've broken a law. So it kind of comes down to this. Let's say, for example, a guy's doing a walk by himself and someone calls the cops and says, hey, this guy pointed his gun at me. Well, they basically made an accusation of a criminal offense. That means the cop would have reasonable suspicion. But if all they got was a phone call that said there's a man out here with a gun, in plain English, what they got was a phone call reporting no crime whatsoever. That gives them no suspicion at all. That gives them nothing to work with. Now, and this is the key, the cops, they're just like anybody else. They can walk up to you and ask you a question any old time, but they can't make you stay there and answer that question unless they have reasonable suspicion. That's important. So, in plain English, the officer has to be able to say that he, the officer, thinks that you, the person he's talking to, not just any old buddy, but you specifically, broke a particular law. He doesn't necessarily have to have just one, but it has to be a pretty short list of laws that he thinks you broke. And furthermore, he has to be able to say, here is my shred of a fact, something that I can name and describe. And this is why I think you broke the law. If he doesn't have that, all of that, then he also doesn't have any authority at all to detain you. And you can turn around and walk away, and if he doesn't like it, that's just too bad. You're going to get messed with if you do that. Now, this is just a fact. And we're going to have to work on putting a stop to that. But in any case, this is the truth. This is just the way that it is. If an officer doesn't have reasonable suspicion that you broke the law, well, then guess what? He has all the authority of the mailman. And you can turn around and walk off. Now, there's another part to that video that, frankly, made me mad. And I'm going to address that now. That was the officer insisting that our guy show him some ID. I'm going to read you the actual law from the Texas Penal Code about failure to identify. This is the Texas Penal Code, subsection 38.02, failure to identify. And it says, a person commits an offense if he intentionally refuses to give his name, residence address, or date of birth to a peace officer who has lawfully arrested the person and requested the information. So, number one, you have to be under arrest. If you're not under arrest, then you are not required to provide identification. And we'll get to the detained part here in a second. And furthermore, that arrest has to be lawful. Some trumped up BS that they pulled out of the thin air just because you made them mad, that doesn't count either. So, if you are lawfully under arrest, then the law in Texas requires you to provide identification. Well, what about if you're not under arrest? What if you're just being detained? And let's assume that it's a legal detention. Let's assume the officer has reasonable suspicion. This is the next section. A person commits an offense if he intentionally gives a false or fictitious name, residence address, or date of birth to a peace officer who has lawfully arrested the person, lawfully detained the person, or requested the information from a person that the officer has good cause to believe is a witness to a criminal offense. So, if an officer has detained you, the law requires you, if you tell him anything, it requires you to tell him the truth. But it doesn't require you to tell him anything in the first place. In other words, if you have been detained lawfully by a police officer, you absolutely do not have to identify yourself to him. And there it is. Subsection 38.02, the failure to identify statute. So this belief that officers have that they can detain you just because they say that you're detained, and then once you're detained just because they say you're detained, now you have to show ID to them, is just a bunch of crap. It's just not true. It's as simple as that. It's wrong, wrong, wrong. Anyway, that's the way it is. I'm going to start doing some of these, do a little breakdown of stuff like failure to identify and reasonable suspicion and so on and so forth. We got to start, we got to get that clear so that everybody's on the same page with it. And by the way, this stuff I just told you about, that doesn't change just because you're in Austin or San Antonio or Wichita Falls. That is the same statewide. From Beaumont to El Paso, from McAllen all the way up to Amarillo, it's the same. The whole thing is the state of Texas, and that's the law of the state of Texas. So anyway, all right, that's it. Talk to y'all next time.